And so you and Ms. Renee and Ms. Joby all just sit there like you're just clueless wonders, like you can't piece this together. Like I'm going to ask the question, ma'am. I guess I don't mean any disrespect, but I'm asking the question. Are you all retarded? I mean, I really have.
All right, you know what?
Are you
I've listened long enough. You are not going to call names to me. You do mean to be disrespectful. You do mean to call names. So please, stop. We do need to update the calendar to reflect that Mr. Sachs is pro per and no longer is represented by Mr. Nadig. After today's date, Mr. Nadig will no longer need to appear. Let's first start with a defendant's motion to acquire complete case file from Mr. Nadig.
It's right here. Again, I'll mail it to him. Again, I'll just do it certified this time.
Okay, Mr. Sachs, did you receive the mailing the first time?
No, I didn't. What address did Mr. Nadig say that he sent it to?
I don't know. That's back at the office.
Okay. Mr. Sachs, what address would you like it sent to? Just so we can put it on the record and I can order him to send it to that address.
P.O. Box Paron, P-A-R-O-N, Arkansas, 72122.
Okay, so you are specifically requesting the results from the Silver State investigations. Is that included, Mr. Nadig?
It should be on a disc. I will double check with Ken, but yeah.
Okay, include that, so that needs to be as part of the mailing. Mm-hmm. And then I'll set a status check in 2 weeks for you to file the certified return. Got it. All right. So I'm going to reorder that Mr. Nadig send that and then send confirmation of that. The 2-week status check will be?
That is September 11th at 9:30.
No one needs to appear. I just need you to file the certified return at that time.
Yes.
If I don't have that, you do need to appear.
Easy enough.
All right. So then, Mr. Nadig, you are free to go. I need you to send that ASAP.
Done. Thank you.
Moving on to motion to correct the recorder's transcript and dismiss charges. Mr. Sachs, regarding the motion to correct the transcript, I had my recorder go through it again and make some of the clerical errors. Anything that she does here as inaudible or there's kind of feedback, which unfortunately happens via Blue Jeans, she is not able to correct. So she did file an amended transcript as well as an errata attached to that explaining why certain changes were not made, because that was ultimately she can't change what she doesn't hear. Okay?
Well, what I want to do is add for the record, because I understand the limitations of what you pointed out, what she described, and just ask very quickly right at this moment, is Ms. Kirkpatrick the court recorder today?
Yes.
All right. Now, what I want to do, because the only choice I have in this matter is to correct the record after the fact. So, with respect to her August 15th errata, on page 46, line number 1, I am saying that I'm stating for the record under penalty of perjury, and I did that in my filing as well, is that the words that were missing after judicial canons, and there's a dash, and it should say, and is not answering questions. So I want that added to the record. Actually, it's going to be added to the record by default, what we're saying here now. And then by the same token, while we're on the topic, is I move the court to have Ms. Kirkpatrick provide a court file transcript from this point forward. The reason being is that's consistent with my due process rights, and also an opportunity to serve as a checks and balances to ensure that the record is true and correct.
All right, so she's filed her errata answer. You've made a note of what you believe was said versus what is actually on the transcript. The changes are made as reflected in the errata. There's not going to be additional changes.
I was crystal clear on that point, man. Maybe you misunderstood what I said, so I'm going to say it again with respect to the latter part. I move the court to have Ms. Kirkpatrick provide a court-filed copy of every hearing from this point forward, because, again, it is part of my due process rights, an opportunity to serve as a checks and balances, that I have an opportunity to ensure that the record is true and correct.
All right, so you'll have to file a request for a transcript every time. They're not just going to be made unless it's a death penalty case.
When you say refile it each time, what is that document code, ma'am? Because it's like a 4-digit code or 3-digit code. What is that code, please?
What code?
The document code that goes to the top left-hand corner of every court filing, ma'am.
Ms. Kirkpatrick, do you know what he's referring to?
No, it's just a request for transcript order that gets sent to you for your signature.
Okay, so it's just the way that you had filed to get the transcript last time would be the same way that you would do it. Again, I don't understand that. I don't know that there's a document code that she's waiting for.
All right, well, before we started, ma'am, there's just a couple things I need to get on the record.
Okay.
As always, I'm here by special appearance, and what I mean to clarify the record by saying what I'm saying is that my understanding of uttering those words is that I am saying that I'm challenging jurisdiction, that it is not to be misconstrued or misinterpreted as though I am here by general appearance and everything that it entails. The next thing is I'm here under force, duress, and threat, and unlawful coercion. And this has been the case that I put this on the record under penalty of perjury many a time now. And it seems that my words have no meaning and that this for-profit corporation doing business as the 8th Judicial District Court just does as it pleases. So all I can do, ma'am, is just get it on the record over and over again that I've got this on the record so many times that what it shows, as far as I'm concerned, is the level of fraud that all of you perpetrate every single time that you force me against my will to participate in these hearings, ma'am. So, having said that, I reserve all my rights. I waive none. The other thing I want to ask is, do the Nevada revised statutes abrogate the Constitution?
You're aware of how constitutional law and the Nevada statutes interplay. The Constitution
Actually,
is a floor, not a ceiling. The Nevada Supreme Court can add additional requirements, but at the same time, the Constitution is still in play.
I'll ask the question a different way, ma'am.
I don't know that you're going to get a different
It
answer
appears to
because
me-
this isn't like a quiz show. I'm just trying to ultimately rule on the orders that are in front of me. And so
All right, so
you have a motion to dismiss.
All right, let me
Did
ask-
you want to move into that?
in a moment, ma'am, because this is important, because I keep having to attempt to maybe get one or two questions answered when I have a litany of questions, that it would be nice just to power through them once and for all, that I can proceed knowing what I'm really up against here. So the first question would be is, do I have the right to a fair hearing here today? Yes or no?
Yes.
Are you obligated to honor and follow all the judicial canons? Yes or no?
Yes.
Do I have a right to be heard here today, ma'am, in this hearing? Yes or no?
Yes.
Thank you for that. So, one thing I need to clear up the air upon, this has been bothering me for a long time, ma'am, and if you were in my position, I'm sure you would feel the same way, and that is this. And in other words, it's a series of short questions, but it comes to a point very quickly. The first question is, does fraud vitiate everything, yes or no?
I'm not sure in what context that refers to. I can't give you a solid answer on that. I apologize.
Does fraud, if fraud is committed during a hearing or a grand jury, does fraud vitiate the outcome, the decision, to make it a nullity?
I can't answer that. It depends on what type of fraud you're alleging. If fraud has been found to occur,
Well, is it fraud? In other words, fraud is where some kind of malfeasance or something else is wrong. Isn't that correct, ma'am?
I meant the specific instance, but ultimately, I can't answer that any more clearly. You would have to ultimately file a motion. I'd have to determine if there was fraud, and that hasn't been determined here.
Actually, ma'am, I'm going to ask the question here because this is a burning question as well. Did you read the motion that's in front of you? In other words, the motion to dismiss for the court being deprived of in personam jurisdiction. Did you read that filing in its entirety, ma'am?
Yes, I did. And I also read your reply.
Thank you. Now, here's what I want to know from you. Is after reading that, how can it not be clear in your mind of the fraud that has been committed? In other words, I put this on the record ad nauseum, meaning repeatedly, that I'm asking you now, I'm asking you a fair question. What do you actually understand about this case? In other words, if I asked you just to synopsize in 1 minute or less, what is your true understanding of this case, ma'am?
What the filings represent, or what the filings have been made. I'm not going to answer. I'm not going to give you a summary. There's no mechanism in the law that allows you, Mr. Sachs, just to grill the judge on their understanding of the filings in the case. It is a proceeding between two parties. My understanding of what is going on is frankly irrelevant. Ultimately, it will be a jury who determines whether the state has met their burden or not. I am not going to give you a synopsis of what my view of the case is.
Do you have the authority to dismiss the charges sua sponte, yes or no?
Depending on... No, generally not.
What would be the exception, because you're not being, say, clear enough or specific enough? What would be the case where you would be able to dismiss these particular charges sua sponte?
If you had brought some sort of, perhaps if you were not over the age that you could be charged when these occurred, for example, if you were 14 or 15 when this alleged event had occurred, that would be something that I didn't have subject matter jurisdiction over, and that is something I could perhaps sua sponte dismiss. But in general, I understand that you argue that I have no jurisdiction.
Does this court operate under? Is this an outlaw court or an equity court, ma'am?
I'm not sure. I don't use those classifications in my everyday life, so I'm not sure.
Are you treating me as a belligerent because you perceive me as a U.S. citizen as opposed to a man, a natural man, and that you've been taught these things, or somebody has told you to do these things under, say, your own quiet form of coercion, that you have been compromised in some way, shape, or form? Is that what's going on here, ma'am? I really want to know.
I don't believe so.
I
think we just have different views of what the law is and what the facts of this case are. And
am I protected under the rights?
Go ahead.
Am I protected under the rights of the Constitution, ma'am?
Yes.
Are you applying my constitutional rights in all your decisions, past and present?
Yes.
All right, now I object to that because it's been my experience you have not followed the Constitution basically at all, and that I did file a previous motion to have the grand jury reconvene under NRS 172-241. And if you recall, basically at one point you lied during that hearing, which I have on the record, and I have it written down. In other words, my wife's a witness to it, is that you did not follow not only did you violate my due process rights, ma'am, but you also denied my right under NRS 172-241 to have the grand jury reconvene, because there's a specific element in, I believe it's paragraph number 5, that says, if the person did not receive adequate or reasonable notice of being informed of the grand jury that it was going to take place, is that the grand jury must reconvene. And so I object on the record very loudly and very clearly that you have not been following the Constitution and you haven't been following the NRSs. So it begs the question, what are you operating at equity where you just basically do what you want willy-nilly? In other words, you just do whatever your conscience tells you. Is that how you're operating, ma'am?
In no way is that true.
All right, I take exception to that. I object to that as well, because that's been my experience, ma'am. Because any reasonable person who stands back and looks at this and reads the court filings would come to the same conclusion that you are not following the Constitution, you are not following the NRS's, ma'am. That's what the record shows, and that because you are covering up for the fraud that Ms. Joby committed at the grand jury, specifically that she did not reveal all the exculpatory evidence that was there. She allowed perjured testimony by Chesley Grayson and some other people, and that she allowed facts not in evidence. And so I put that in an affidavit, and it seems that you couldn't care less what an affidavit is or the meaning behind an affidavit, or again, the importance of it, is that you are not following the Constitution because you're violating my due process rights left and right, and you're not even following the NRS's, ma'am. So how can you sit there and say that you are doing these things when the record shows 180 degrees the opposite, ma'am?
I see it differently than you do. I have, from my perspective, been following the NRS statutes as well as the Constitution. You may see it differently, but reasonable minds may disagree.
All right, so
It's
I'm
all
putting on
noted for
notice,
the
ma'am.
record.
I have some court watchers. Ma'am, and so the spotlight is going to continue to come on you stronger and stronger because what you've been doing is dead wrong. The fact that you hold on to this case and don't dismiss it sua sponte speaks reams to basically how corrupted and how compromised you actually are in fact. And so that was brought up basically in the motion ad nauseum. And so again, I'm going to say this for the record. I have been framed. How hard is it for you to understand, ma'am? I have been framed, and so is my wife. Now, how do we know that we've been framed? Because Detective Slack never conducted anything that resembled an investigation. How do we know that? Because I did an extensive affidavit that dissected every one of the lies that he put forth in his affidavit. And that's on the record, and it's really your responsibility to read that. I don't think you've read it. I wish you would have read it, but I don't even know that it makes any difference that you would read it. Because you're just doing what you want anyway. And so the other this is that our boy was never released from UMC Children's Hospital in good condition. How do we know that to be true? Because Detective Slack provided the surveillance video that shows me, the daddy, carrying a broken boy out of the hospital. And it is absolutely remarkable. Not you, and not Ms. Renetti or Ms. Joby, or even Detective Slack wants to scratch their head and say, wow, that's interesting. So the medical records from the hospital, from the doctors that lie and say, oh, he was released in good condition. How could he be? We have video that shows otherwise. And so because he was not released in a good condition, it follows that he was released in a damaged condition. What did my wife and I do over the next 7 days? We spent $1,100 to heal him with safe and effective remedies that included a Myers cocktail IV. And so you and Ms. Renetti and Ms. Joby all just sit there like you're just clueless wonders, like you can't piece this together. Like I'm going to ask the question, ma'am. I guess I don't mean any disrespect, but I'm asking the question. Are you all retarded? I mean, I really have.
All right,
asked the
you know
question.
what?
Are you
I've listened long enough. You are not going to call names to me. You do mean to be disrespectful. You do mean to call names. So please, stop. We are here for a specific motion, which is a motion to dismiss because of lack of jurisdiction that you claim exists. You can be heard on that specific grounds, but you can't just call people retarded. And by the way, no one in polite society uses that term anymore because it's completely offensive. What did you want to say regarding the motion to dismiss?
All right, let me go through my questions because I asked a lot of questions.
You are
And
not
once
going
again,
to
my
be.
questions
I
never
am not
get
going to be answering questions. This isn't like a question and answer portion. I apologize that you thought it was, but it's not. I'm going to shut it down at this point. We are on for the motion to dismiss. Did you want to argue anything further than what was in your written motion?
I'm going to argue the point that I have a right to be heard, which you agreed to. You agreed to follow the judicial canons. If I'm not allowed to ask my questions, because let me read from the last hearing. Here, I'm quoting you. You said she doesn't have to answer the question, meaning Ms. Renetti, because she, and then there's a dash, you're not just allowed to ask each other things. She wouldn't be allowed to question you in this manner either. It would have to be through a filing or something that's going on through the court. Well, I'm here to tell you, ma'am, that Ms. Renetti did not answer my questions in this filing, nor did she, and I guess she would have a point for the reply to opposition, but what I'm saying is that you instructed me of what to do, and that she didn't comply by answering my questions that I posed in the motion itself, ma'am. So where does that leave me? That leaves me with you telling me I can't ask questions. I'm like, wow, this seems like a catch-22. Like I can never just get anything answered, ma'am. So what I'm saying is, I have a right to be heard. You agreed to follow the judicial canons, and I have a right to ask these questions because it's going to help me understand what I'm really up against. Because my position is, and I hold to this, is that this court and the members and the officers of this court are acting fraudulently over and over again. And so I'm making the most vast record to protect myself and my interests because this is unbelievable what has happened. I told you it's a frame job. You don't care. You don't read the record. If you do, you're just going to keep trucking along because you're going to rubber stamp in everything Ms. Renetti does. So I need to ask some questions, ma'am, to understand. So from this last hearing, all right, so you had said that you didn't agree to be a trustee from the last hearing. And so my response is, I don't agree to be a trustee either. So now the question is posed to you as me being the grantor beneficiary, is who is the trustee, ma'am?
As I have previously stated, I'm not answering questions in this manner. This isn't what this hearing is for. The hearing is for the motion to dismiss, which you filed. Do you want to be heard on that? This is your final opportunity, sir.
Yes, I do, because you leave me no other choice. So you box me in a corner, so you leave me no other choice. The
Okay.
answer is yes.
Go ahead.
As the expression goes, I don't want to make an argument. I want to ask questions for clarification. The reason being is I fail to see how this court has in personam jurisdiction over me, the man, when you are looking for a corporate dead fiction to basically attach yourself to and say, so I don't consent to be a corporate fiction. I don't agree to be a corporate fiction. It's against my will to be a corporate fiction. That where does this court require my consent to have in personam jurisdiction?
No. Most people wouldn't consent to in personam jurisdiction in a criminal case if that were an option to them. However, pursuant to NRS 171.010 and 020, I do get jurisdiction over you because these actions were committed within the bounds of Clark County. And so your consent,
All right.
unfortunately, is irrelevant.
All right, so I object to that. The reason being is you completely skipped over in my reply to opposition. You completely skip over my question today is I don't agree to be a person, ma'am. I'm a man. I am a living, natural man. I'm not a person. A person has a very specific legalese meaning. And so I don't agree to be a person. I'm not a person. I don't consent to being a person. It's against my will to be a person. So in that vein, ma'am, you are 100% in the wrong. That's my position. And that it's not possible for me to be a person because I'm a man.
All right.
So let me ask the question. Am I a man? Yes or no, ma'am?
All right. So at this time, I find
Ma'am, you
that
can answer
under
this.
NRS 171.010 and 020, I do have jurisdiction over this matter, in personam jurisdiction, and so the motion is denied.
Thank you, Your Honor.
You made a claim, ma'am. I object. Your
Your objection is
you're
noted
just
for the
responding.
record. All of your objections have been noted, and the record is complete. Thank you, sir. Have a good day.
I filed an